Hey y'all, I want to talk about something that actually comes up fairly often in trial, and that's getting witnesses to the trial depending on their status, if they're a party or a non-party. So if you have a party, and in many cases you've sued the driver, you've sued the owner, or maybe your prior counsel has, and you send a notice to appear 10 days before trial, 20 days if you bring documents, so that you can make the parties come, and it's easy because you just serve the defendant's attorney. But what happens, like in this case, when the trial gets kicked, maybe new counsel like us come in, and we realize maybe there's too many defendants, you have no coverage differences if you streamline the case, you don't want to look like you're suing the entire family like we did, and now someone who had a notice to appear as a party has now been dismissed for a waiver of costs. Now that they're no longer a party, the notice of appear doesn't require them to come to the trial. So you've got to serve them with a trial subpoena. Now that's easy if the defense counsel wanted those people to testify. Realize that if the defense lawyer is not going to agree to produce those people, you got to serve them with a trial subpoena, and that has to be a reasonable time. There's no set time. It's a lot of different factors. And if you want them to show up with documents, you've got to serve a trial subpoena with a check mark called a subpoena ducis tecum. So you always have to understand where they're going to fit in your case, and one way of making it easier is to attach what's called an on-call agreement, where the witness who served with the subpoena will agree to show up on 24 hours notice. Most judges find that effective. Come on now.